So, welcome to our semi-regular webcast series at Syracuse University College of Law. We talk about various issues regarding intellectual property and technology, and I'm happy to have with us today Professor Rebecca Curtin from Suffolk University College of Law, where she teaches copyright and property and trust and estates and all sorts of property and money-making ventures, I guess, or semi-money-making ventures.
Yeah.
And she holds a JD from University of Virginia and a PhD in English and American languages from Harvard University. So welcome, Rebecca. Thanks for joining us.
Thanks so much for having me.
Yeah, so we've written on a number of interesting topics. I was looking at your publication list, but we're going to talk about, I thought, your interesting book chapter called Locke's Own Literary Property. And I can't do this, I can't do the punctuation marks orally, but I'll try to. But the own and Locke's own intellectual property is in parentheses. Is there any reason why you picked the parentheses rather than the quotation marks? Or?
Right. Well, because the paper is trying to do sort of two things at the same time. One, to talk about Locke's theory of literary property, but then also to compare that theory or to think about the relationship between that theory and his own actual commercial transactions, like how he might have conceived of his own actual literary property.
Yeah, and so I really look forward for talking about your book chapter and your work more broadly, because I think it is fascinating. We tend to forget that these theorists of property and law probably also engaged with property and law in some ways, and it's so great for your chapter. Just a little bit of self-advertisement, I guess, that the book chapter is coming out in a edited volume from Elgar called Forgotten Intellectual Property Lore, and that should be coming out later this year, all things knock on wood. And I'm the editor of that volume, and you're in great company with 13 other authors writing on different aspects of, sort of as the title suggests, overlooked or ignored or forgotten aspects of intellectual property law. And I thought your chapter was just really fantastic because of the different dimensions to it. As you mentioned, both, is pun the right word, about Locke's theory of intellectual property, as well as his own ownership or control or management of literary property. I thought it might be interesting to start off, because I think you spend a lot of time in the book chapter really developing a very interesting analysis of what exactly is literary property. And did you want to give us maybe a bit of a background on that term? Not a whole history of it, obviously, because that would, but at least Locke's, the way Locke relates to literary property, is the usage of the term. And
Right. So first of all, I think it's important to emphasize that while he does use this word or this phrase, literary property, it's not the only word he uses. He also uses the word privilege. But that when we acknowledge historically that he used this word property, I don't think that necessarily then determines a kind of absolute or universal scope to what that means, right? Because there were so many different forms of property, even in their understanding in the 17th century. So I don't think that the sort of the table stakes in using that word are necessarily determinative or in a kind of absolute or maximalist way.
Mm-hmm, mm-hmm.
The other really interesting thing, I think, that was surfaced for me by the research in this paper was that Locke connected first with this issue of literary property as a reader before he connected with it as an author. And in his sort of earliest commentary we get on the political issues of the day with the Stationers' Company monopoly on classical authors, he thinks of it in terms of the burden that it places on readers and scholars, right? That it lowers the quality of the editions that are available to them. And then on top of that, he extends that idea, and that there's a burden to the public in this perpetual monopoly in the classical authors, that there's no theory on which the stationers can claim to deserve that perpetual right and the ability to print these authors. In fact, he says, he that prints best deserves best and should have the sale of them. So we get this sort of reflection of labor desert theory, even as he's thinking about, gee, as a reader, I sure would like to have competition in the importation of editions of classical authors. Right. So I thought that was a nice point to make before I think of him as a kind of commercial author dealing with his own work.
And just to clarify, the readers would like competition because of what, better editions, more choice, and so forth. You know, one of the things that's always intriguing, this is sort of maybe getting off the track a little bit, but it just struck me. We fight over the term property a lot as legal scholars, but how about the term literary? So these would be works that would clearly be in the public domain at that time too. Were publishers claiming copyrights, for example, in Cicero and Caesar's Gallic Wars and all that?
Yes. Well, although through a letters patent, the stationer's company had perpetual rights to prevent, for instance, the importation of a competing edition, and those rights were perpetual and unlimited.
Yeah, even in books that would be in the, I guess, classics. I mean, I think that's so. Locke's concern was not just for original works at the time, right?
That's right. And in fact, he does get to by the time we get down to 1695, we have correspondence from him talking about the various bills that are being proposed to replace the Licensing Act. And by the time we get there, he is thinking in terms of original authors and is concerned about their ability to leverage their literary property and sell it, frankly, to printers and just disseminate their works commercially. Right. So he does get there, but it takes a while, right, for him to make that kind of, I think, intellectual leap, which eventually we do get in the Statute of Anne, in which they think we can think of authors themselves as initially holding a right to print, which they transfer, as opposed to, say, thinking that authors have an ability to control their manuscript, which is then sold, and then members of the stationer's company have a term of years or a perpetual exclusive right to print those things that have been registered for them.
And the works of Locke Locke wasn't, like, as I know, a potboiler writer. I don't think he's known for his romances or whatnot, but it was his philosophical writings, right? His essays.
Yes. Largely philosophical writings. Also some, what we might think of as economic treatises. He wrote about the theory of money and currencies. There's a scientific treatise that is the subject of one of these contracts, although he's claiming the ability to control that text as executor of a friend's estate. Robert Boyle's.
So does literary, this has always intrigued me, the literary, we think about, for example, in the U.S. Constitution, promote progress in science. And I remember I had a delightful but frustrating student who asked the question, well, if it's about promoting science, why do poems and movies get protected? And it was not a, it's a legitimate question, because the whole notion of entertainment and information and science is a very different meaning now than it did back then. Were we talking about a period where the novel and entertainment was also at issue when we're talking about literary property?
Oh, sure.
Getting at the literary,
Maybe not technically novels yet, as a kind of genre as we know and love it now, but certainly more popular, or more things we would think of as literature, as opposed to say sermons and philosophies. But maybe what we'd be talking about is epic poems, right? Maybe something that would count as more pure literature.
Yeah. Do you think Locke was considering that too when he used the phrase literary property? Is that
what a great question? I mean, I think I'd have to say yes. I mean,
Yeah,
he uses the term broadly authors, right? He doesn't
yeah, yeah.
he doesn't limit it, say, to scholars, right? Which would be
Right,
the other
right.
word that might apply to him and the kind of writing
Hmm.
that he was doing. So yes, I think that's fair to say that they had a concept of literature.
Right, right.
Yeah.
And it's interesting to see from your writing about how his notion of literature and property kind of evolved. I think you give us a good description of that. We'd like to explore that more and like to hear more about that. But it might be useful to think about how that relates to copyright law itself as it existed. I mean, I think you write really, really interestingly in the paper about his views on the Licensing Act, and you mentioned the Stationers Company. Do you want to elaborate on that for people who might not be up on 17th century history? I had to find
Sure.
myself, I'm glad Google was only a few taps away while I was reading your paper.
So yeah, so it's I think it's so interesting the way now you're asking me about relation to copyright, right? Because
Yeah,
I do think it it's important to remember, first of all, that the world that they lived in has been gone for a very long time, and
right.
the world belongs to us now. So
Yeah,
when I
yeah,
deploy these sort of historical narratives, it's not because I intend to try to steer us in where we should go next. It's more in understanding historically how we got here,
yeah,
right?
yeah.
So, and I think it's important to remember that the modern concept of copyright is not necessarily the same thing that they were talking about in their world
Right,
back then. However, it is interesting to work with Locke because of how closely he interacted with the members of parliament who were considering how to regulate the press at this moment just
right,
before we get the Statute of Anne,
right,
which is our sort of first statutory form of authors' rights
right, right.
in printing. The thing that is closest, at least, to what we mean when we say
Yeah,
copyright, right? So
yeah,
there is there's a historical connection there
yeah,
that I
yeah.
think is interesting and worth exploring. And it has been fascinating to me with this work to see how, in his own experience as an author, and in the way that he talked about these issues, while the monetary side of the deal is obviously meaningful and important, it is not the only thing. And
Right,
we in sort of American modern copyright doctrine tend to emphasize the kind of instrumental incentivizing via the kind of pecuniary power that
yeah,
exclusivity can give to copyright holders. But I think it's interesting to see that even at its origins, that's not the only
right.
thing that was important.
Yeah, I mean, I should have looked at this before, so maybe I should press the pause button. We can Google it together if we don't know. But I think John Locke had passed away by the time of the,
1704.
yeah, so, but he
Yeah.
was gone by the time of the Statute of Anne, right?
Yes.
Yeah, so, and it didn't appear that he had any influence on it per se.
Not no, not in that
Yeah,
sense.
yeah,
Although there had been um, multiple debates
right.
in Parliament
Yeah,
after the expiration of the Licensing Act. He
yeah,
did
yeah,
die during that sort of the interregnum. It's not between two kings, but
right, right,
the space between the
right.
expiration of the Licensing
Yeah,
Act and the
yeah,
passing of the Statute of
yeah,
Anne. So he
yeah,
died in that gap. But he was certainly involved in the discussions around what should replace the Licensing Act. He
yeah.
just didn't live to see it.
And that was the Licensing Act was also the subject of Areopagitica, right? Or
Yes,
am I okay, misremembering? Okay.
yes,
Did he
yes.
have a connection with Milton, or were they sort of a
Not that
separate?
I'm aware
Yeah.
of. Not that I'm aware of. Although we do have Milton's contract for Paradise Lost as well. I've
Oh,
written about
interesting.
that contract in a different article.
Oh, wow.
It might be
Okay.
interesting to think about
Yeah, to compare
that
those two.
connection too. You could.
Yeah. Well, we can talk about that in a few minutes when we
Yeah.
get into the transactions. But I want to explore. Do you want to maybe elaborate a little bit on the Licensing Act for those who may not, as I said, remember all the nuances of English history?
Yeah. Okay. So for oh gosh,
Yeah, I know
maybe
there's quite a bit.
100 years, 100+ years.
Yeah,
The way copyright, what we would think of today as copyright, or what maybe they would have thought of as the right to print, worked, was that there was a licensing act that gave the stationers company the power to police itself in return for maintaining a registry of the things that master printers printed, and the number
right.
of master printers was controlled by the stationers company, which is the professional guild of booksellers and printers. The people we would think of today as publishers would be
Yeah,
booksellers. Sometimes printers worked as booksellers as well, but they come together in this professional organization. And because the Licensing Act requires a censor to approve of the publishing of each work,
right.
um, you get this kind of agreement between the stationers company and it was, I believe, Mary Tudor's regime,
Right.
that at its initial form, that the way it would work is that a printer would come to a censor, get it approved, get what they wanted to print approved, and then register that in what was called the stationer's register. There are these little entries that would include information like the member of the stationer's company who is planning to print this thing, the title of the work, and sometimes also the identity of the author, the fact that it had been approved for printing, and the fact that they had paid this small fee. And once you had done that, then you, as the printer or bookseller, whoever was registering the copy on their own behalf, would then hold a virtually perpetual right to print that work. Now, there are some finer details about whether that right really was perpetual. For instance, if you just sat on those rights, allowed something to go out of print,
Yeah.
whether, so there are, it's a long history, and there are finer details around exactly how the rules within the stationer's company worked. But generally speaking, that was the form of an exclusive right to print. Now, there was one other form, and that was a direct printing privilege from the Crown. And the Crown could it usually took the form of a term of years. Authors did sometimes get those. There are a handful of authors who were given this ability to control printing of a certain work for a certain number of years. I've written elsewhere that I think that's a strain of the Crown looking to advance the progress of arts and sciences by incentivizing particular works. A nice example is an early Latin textbook by a man named Linacre, who might not otherwise have been interested in producing a Latin textbook in his time, because at that point it wasn't a very prestigious thing to do. So he gets this exclusive right to print from the Crown, and we assume that allows him to leverage a better price or better compensation that he would have otherwise gotten, right? So that sounds familiar, doesn't it?
Right.
With our kind of instrumental, oh my goodness, hold on, excuse me.
Yeah, let me put this on pause.
Okay, right. So, but back to the Licensing Act. So it expires in the late 17th century, and partly because it has this connection to censorship, it takes with it this exclusive right to print as we've understood it inside the stationers company. And they find it very difficult to get Parliament to pass it again, or to extend the Licensing Act, because censorship has become a hot button issue in a world in which there is an active opposition. And I think both the opposition and the majority can see the dangers in having political power in censorship prior to something appearing in print, right?
And John Locke himself face a possible prosecution, right, for his
Yes, that's right.
support of James
That's right.
II. Is that
Yes. Yes.
yeah,
Earlier in his career, he had in
yeah,
fact had to flee England and live in Holland for some time. So I think there was a very real sense that there was it was politically difficult to
right,
get
right,
another licensing act passed. But then without a licensing act, it was unclear what the mechanism would be for the stationers company to continue to support its ability to leverage exclusive rights to print,
yeah,
right?
yeah, interesting,
So this alternative argument begins to emerge, that the real usefulness here is in helping authors out, helping to incentivize them to create works, helping to make sure that they can provide for their families and their children and widows, right? If how can they do that if they can't sell what it is that they've written? And it's difficult for us as members of the stationers company to pay them if we're not sure that we're going to have some exclusivity in what we're
yeah,
able
yeah,
to print, right? So this argument emerges. It's one of the last arguments they use. They use a
right,
number
right,
of others, but it emerges at just around the turn of the century. So in the early 1700s, we start getting these arguments. And in fact, we could push that down to 1695
yeah,
in some
yeah.
of the writings of Locke and his correspondence with
Really
his.
interesting. As I mentioned, your chapter will be forthcoming in the Forgotten Intellectual Property Lore book, and just to give that book a little bit more advertisement, you talk a lot about the commercial transactions that John Locke. And so I'm still working on the table of contents of the book, but I'm thinking of pairing your chapter with the Robert Spoo's chapter on James Joyce,
Oh, really?
because James Joyce, with his poems, and again, I'm not doing Professor Spoo's chapter justice here, but had problems with censorship, had problems with publication, and there were some very interesting ways in which publishers kind of established publication rights and protections with respect to James Joyce poems, in the early 1900s. It's a really interesting parallel that people may not have thought about.
Oh, that sounds
Uh,
fascinating. No, I'm
yeah, so
very
it's
eager
gonna
to
be
read it.
interesting to. I'm working on the introduction still, so it's fun to kind of see these parallels between all the different chapters. But I mentioned that because you do talk a lot about and I think that's one of the pieces that's original. Many pieces that's original to the chapter on the actual contracts that John Locke entered into with the publishers, and we'll have some time to talk about that for a minute. But um, I guess we usually think of this is kind of going back now to like legal theory, that a lot of contracts are negotiated against, property rights or whatnot. That might be kind of one version of a law and economics story, that we have certain property rights that parties have, and then they want to transfer the rights or portions of the rights through contract. What's kind of interesting about this example, the John Locke example, is that the property rights seem to fairly murky, from what I
Yeah.
could tell. Is that accurate, or?
I think that's fair to say. And that there's sort of a combination of professional norms and practices within the stationers
Yeah,
company that help authors to kind of leverage their physical manuscripts into something more. And that something more is what I'm really interested in looking at some of
yeah,
these more innovative transactions that we have some evidence of. And
yeah,
I do think it's fair to say that in the run-of-the-mill transaction, they were selling the physical manuscript and they got paid a single down payment,
right,
possibly with a promise for some copies once the impression had been printed. Um, but we also see in some exceptional transactions, um, authors taking that ability to at least control first publication,
yeah,
right?
yeah,
Because they have physical control of the manuscript, they have
yeah,
kind of de facto control of first publication. And it
yeah,
does
yeah,
seem to be as a commercial practice, stationers respected that right of first publication.
yeah, yeah,
That is, or the need to get permission for first publication. We do
yeah,
see a couple of examples in which there's an objection from an author that something has been circulating and a printer gets a hold of it. But generally speaking, we think that they respected that first publication. Well, so if you have that, then you've got some leverage. You can start
Right.
asking for things. And we do see
Yeah.
authors apparently asking for things like control after the first
Yeah.
publication. And that's where I think we can begin to see the concept of author's copyright emerging in these transactions.
Yeah. So when you think about Locke's own literary property, so taking away the parenthesis, then it is sort of the right in the manuscript that we're talking about in some way, right? I mean, that's what, and thinking about the technology at the time, there was only one way to get access to the manuscript, which would be
Right.
to get
Physical
to
access.
right. Yeah.
Yeah.
So this is the analogy. I guess you needed that analogy to property to sort of. I guess if the manuscript had been stolen and then copied, there would be some property right in the physical paper that was stolen, but the literary property is also saying that property right, sort of analogous to a real property right or some sort of common law notion of property, would extend to what's written on the manuscript. It's sort of the way to
Yes.
think about literary property. I mean, it's we obviously see the parallels to modern day copyright, but
Yes.
it really wasn't copyright. It's sort of, I think, one of the lessons here. Does that seem accurate? Or
I think that's accurate. Although, what I was saying before, that they use this leverage they have in the
right,
access to the physical manuscript to
right,
ask for something more. And when we begin to ask for something more after post-publication, then we get this concept of copy, right? So they would the stationers
right,
themselves would refer to it as buying copy, and it's super confusing because there they mean not the physical copy, but the right to copy.
right.
I register that as he registers this for his copy, the records will say,
Yeah,
or
yeah,
for sole right and title to
right,
copy
right.
in, they
Yeah,
will use
yeah,
these phrases, right? So when a stationer uses copy in that context, they mean right to print. Well, then Locke comes along, and by the time we get to the mid 1690s, he's got a couple of agreements with his publishers in which he has them sign a little kind of affidavit that says that sole right and title to the copy is and remains in Mr. Locke after the impression we are currently printing.
interesting.
So now we're talking about something else. He's given away the physical manuscript, in fact, has been
Yeah,
printed, and he's got his publishers agreeing that he still holds the copy. Well, what can that possibly mean? And I think as a matter of practical reality, what that means is that his publishers, as members of the Stationers Company, are going to register that work and defend the right to print it on their own behalves against other stationers, but they promise not to print it without his consent. Right?
Interesting. So it's not a pure contract right. I mean, because it's you have to ask where that right comes from, but it's not really a creation of contract, except it's sort of maybe a negative right under the contract or right.
Piggybacking on their ability, maybe as stationers, to control it, but agreeing with him that he retains control. And even when we get formulations of the agreement in which they say the copy remains with Mr. Locke, we have to assume the agreement includes his ability to bargain with others.
Yeah. I mean, I don't have.
They won't get in the way of that either.
I don't have Robert Spoo's paper fresh in my mind. It's been a while since I've read it, but I think when he was writing about the publication of James Joyce's poems in the U.S., I think he spent a lot of time talking about an agreement among publishers. So that's interesting, and there's raised interesting cartel antitrust, issues there. But I think the Stationers Company case, would there have been an implicit agreement then among publishers? I mean, I guess that's part of there was sort of an implicit agreement.
Yes.
Right. So.
But this is the practice. We register it in our. We make an entry in our registry, the Stationers Register.
Yeah.
And then the person who has recorded the entry is the person who retains the ability to print it again.
Yeah. And I guess
with the understanding that it's totally transferable. A
lot of the modern views, Lockean theories of IP, obviously, are kind of anachronistic. maybe not completely, because they try to looking at it in modern terms of property and legislation and things. But was Locke really thinking about literary property as sort of a common law? I mean, what we think about now is a common law right. I mean, he wasn't thinking about it as a statutory right, obviously.
Yeah, because there wasn't a statute.
Yeah,
Right. There
yeah.
wasn't a statute.
So it'd be an author's
That,
right.
well, although they ended up creating one, right?
Right, right,
That gave dimension, and ultimately we know what happens by the late 18th century
right,
is that it's settled that the Statute of Anne has replaced
right,
common law copyright, at least in published works, right?
right, right.
So, but the status of common law copyright, I think, remains somewhat murky, and there are judges who disagree about it through
Yeah,
the 18th century. And there's wonderful work that has been done by Tomas and Ronan Deasley,
mhm.
and that would be the place to go.
Yeah, no, it's interesting
Yeah.
just to think about it. I mean, what? First of all, none of these agreements were litigated, so we don't have any. So we don't know exactly what a court would have made of them, right?
Well, I don't know that we
don't-
know that. I
Okay.
don't know that we know that. So there, in that 2016 piece I wrote called "The Transactional
Yeah.
Origins of Copyright," I've pulled together what evidence I've been able to find.
Yeah.
There, the problem is there is an internal court at the Stationers Company that resolves disputes, the Court of Assistance.
Yeah.
And we have records from that court,
Yeah.
but they don't tend to tell us a whole lot about, say, what the arguments were before the court. It mostly discloses remedies.
Mm-hmm.
And there are a few cases from this time period that include payments to authors.
I see.
So that suggests to us that there are maybe agreements between stationers and authors that are getting adjudicated in some way in the Court of Assistance. But it's hard to know what those agreements look like because we don't know the full picture of what they were arguing about. So maybe there's that. I know of one case about in which heirs were attempting to get a remedy for breach of a contract with an author and a publisher prior to the Statute of Anne. And I just have to guess, that one I came across entirely by accident in the bibliographic literature, which is a great place to find this kind of stuff. People, bibliographical scholars or history of print scholars might write about this kind of thing. But the interesting thing about it is I'm not sure where to go to look for them, right? Because they would really be breach of contract places. There may be more of them that are kind of lost in a sea of contract cases somewhere in the English reports that just haven't sort of surfaced in some way as cases that would be relevant to our understanding of the emergence of copyright. Yeah. So I want to keep looking. I'm not sure that it's the case that they were never adjudicated. I'm just not sure where to find them.
I'm still trying to conceptualize it, and maybe I'm just being a bit slow, but I guess it would, if Locke's agreements had been litigated, I guess this restriction on Locke retaining the right for future copies or the right to copy would be sort of some sort of limitation on the publisher's right.
Yes, that they've agreed not to do this.
Publishers are doing. Okay.
Yeah. So, and they've been given consideration in the form of the ability to print the work in the first place.
Yeah. So let's talk a little bit about those transactions, because those are pretty fascinating. I think all in all, you talk about 6.
Yeah.
You go through all of them. I think one of them was in the will,
and that's right. Plus his will.
Yeah.
And it's worth noting that this, of course, is not a complete set.
Right.
We know he wrote more, and we don't have any agreements attached to some of those works. It's also not clear that every piece of documentation that would be relevant to the agreement has been preserved, particularly in those cases where all we've got is a little, like the thing I referred to as an affidavit, right, or some kind of assurance that the copy remained in him. We don't have an additional set of provisions regarding exactly how those works were printed, and I'm sure he must have worked those details out because we do have in his other agreements provisions of those kinds, right? So
Yeah.
it's just the caveat is that I think the picture is not complete.
Right. Right.
But the picture that is drawn by the documents that we have, I think, is a tremendously interesting
Yeah.
one, right? So, where should we
Yeah, I
go?
mean, I guess at the starting point, it seemed like just as an overarching thing, it seemed like Locke had a lot of, lack of a better phrase, sort of bargaining power
Yeah,
in some of these, right? And that's what you're trying to get across. Is that something he earned, or is that something you just force a personality and will? I mean, do
yeah.
you have a sense of where that came from within his own career? Some of these agreements were, I mean, I think if I remember correctly from your book chapter, he didn't really start becoming kind of a literary, writer, so to speak, or author until his 50s. Is that
That's right.
correct? Yeah.
That's right. Well, he had done he'd been writing, but not
Yeah.
publishing.
Okay.
And he didn't sort of attempt to make any kind of commercial distribution of his works until relatively late in life.
Yeah.
So
So what was
and
his
what
reputation from at that point? Was he more of a sort of he wasn't an academic, was he? And this is sort of just my ignorance about Locke's background. It wasn't
so right, so he worked within the
like Kant being.
household of a powerful patron,
I see. I see.
the Earl of Shaftesbury.
Hmm.
He had been trained as a medical doctor,
Right.
and one of the
That. Yeah.
first things that he did in his patron's household was offer medical care.
I
But he
see.
was also doing other things. He was acting as a secretary. One of the early things that he writes is, or we think had a hand in drafting anyway, was the constitutions of the colony of the Carolinas, because his
Yeah.
patron was involved in that.
Right. Right.
Um, which raises interesting questions, I think, on the other side about the relationship between theory and practice, given what he's written theoretically about slavery
Right.
in the
Right.
founding, liberal documents that he is known and loved for, and what he was
That's another
writing
really fascinating
practically
part of the paper, right?
about the ability of the colonists to have complete control of their slaves, right? So he was doing that kind of thing within the household. He
Yeah.
was also writing things, economic treatises.
Right.
He
Right.
was writing on the side things that would become the essay concerning human understanding,
Yeah.
right? But just not publishing them. He
Okay.
would circulate them amongst a small group of friends. And I think that what happened when he returns to favor under William and Mary, is able to return to the United Kingdom, he wants to gain stature. He wants to move away from this patronage model and to one in which he is a more, what we would think of as a modern, self-supporting author. I mean, at
Interesting.
this point, he's got an annuity. I think financially,
Yeah.
the extra money from the publishing is nice. It's a good thing, but it's not the only thing. And I think in this precarious position that he's used to having been in, actually hiding in Holland, when he comes back to England, he really, he wants to be careful about that. And many of the concerns he has in these contracts, I think, are reputational.
Right. Right.
Right? He's looking to control, for instance, the format and quality of the presentation of the text.
Right.
And in
Right.
this first contract that we have, there are very specific provisions using an exemplar that had previously been printed, of an edition that had previously been printed by that same publisher as an example. He's also concerned about timeline. He'd had an experience where he wanted to print up little an abstract sort of the essay concerning human understanding when he was preparing to come back from Holland, and it took forever. He complains a lot in the correspondence. So he's trying to do that better, right? So when he comes back and contracts for the publication of the full work,
Yeah.
he has very specific provisions about the timing, how long it's going to take, how fast are they going to print it, when can you expect it to come out. He also has an arbitration clause in that contract,
Mm-hmm.
by which if there is a disagreement, his friend, John Freak, is going to be the ultimate arbiter, which I think is fascinating. And as you say, I think it does indicate a certain amount of leverage,
Yeah.
that he was well connected at this point.
Right,
He
right.
comes back from England in part because he has powerful friends who
Yeah,
can assure him that it's going to be okay. And I think the publisher knew that. I think John
right.
Freak is one of the witnesses to this contract.
Interesting.
He was also a lawyer, so he was
Yeah,
probably getting some good advice there.
yeah, yeah. One thing I got, excuse me, one thing just to clarify, and we can talk a bit more about some of these terms. Do you have a sense of how they compare to other or standard contracts, if you will, from the stationer's company or from the publishers? Or
Yeah. Well, again, I mean, the funny thing about that question is that um, there's a selection problem in what has survived,
yeah,
in
yeah,
that we are more likely to have a contract from a Pope, a Dryden, a Locke, a Milton, right? The people who became, and in many cases, even in their own time, were sort of pillars of the canon.
yeah,
And
yeah.
so I think we do have to factor in the idea that there may be some selection bias toward provisions that were actually exceptional in their time,
Right, right,
that the
right.
more ephemeral works from authors of less stature are going to look different. Nevertheless, we do have some of those. There's a really great collection called the Upcott Collection
Hmm.
in the British Library, which was compiled by a 19th century bibliophile who I think was mostly interested in the signatures.
Hmm.
And so there's a lot of 18th century contracts there signed by authors. And that is maybe a little bit more of a representative sample, not all of those works being major works or works by super famous people, although a number of them are names one would know from the 18th century. But when we look at those, if we try to like widen the scope of what we're looking at, so we're not just looking at Pope, Dryden, Locke, Milton, those kinds of folks, then I think it's fair to say, as I was mentioning before, that I think the run of the mill in the ordinary course kind of transaction is this little receipt, and it says, I acknowledge receipt of 7 guineas for my copy entitled, and then there'll be the title of the work, and then sometimes there'll be a little note in addition saying that the stationer who has bought it promises to give me 25 copies of the
Hmm.
work after it's
Hmm.
printed, right? That would be the ordinary course, and that feels really like a transfer of the physical manuscript. However, Locke is not alone in
Hmm.
being an author who has pushed for more.
Yeah,
And these other kinds of provisions that we see in a handful of contracts that have survived are more, they're exceptional but not unique. I'll put it that
interesting.
way.
Okay,
We have other examples of them. I
right.
do think the two contracts in which Locke just says, or the publishers say when they sign the agreement, that copy is and remains in Mr. Locke, that's an extreme form. It's
Yeah,
taking the innovation to its furthest point at that time.
right, right.
But we've certainly seen other contracts that do things like require compensation if you're going to print a second impression, right?
Right, right.
Something that in practical terms, it's not quite the same thing as a royalty, but in practical terms, duplicates that kind of contingent compensation
Hmm.
that we're used to seeing in modern
Yeah,
publishing contacts that pay
yeah,
royalties based
yeah.
on copies sold.
Is that something you've written on, comparing it to these other contracts you mentioned? I know you mentioned you published on another piece related to.
Yeah, so that was where I went first, right? That 2016 piece.
Okay,
It's in Columbia Journal of Law
okay, yeah,
and the Arts,
um,
Transactional Origins of Copyright. Just
right,
tried to gather as many of these examples where authors are leveraging that right to the physical contract or physical manuscripts into something more. I gathered all those up to try to see where I could see some concept of authors' rights post-publication emerging.
mhm,
So you can see that piece gives, I think, a fair
right,
array of what the other exceptional contracts look like.
Would be okay. Okay.
But
Yeah.
we see a lot of these things that we're talking about in
Right.
Locke's terms.
I'll post a link to that article as well, and
Oh, great.
this
Yeah.
chapter will be available. I don't think we can circulate it at this point, but we can discuss that separately. But it's really fast. You know what? Another point you mentioned in the book chapter is about Locke's views on translation. He was didn't really view. I think the sentence I hear,
Mhm.
Locke never attempted to interfere with or profit from the
Oh,
translation. Yeah.
oh,
So
yeah.
you
So
want to
that was
elaborate that a little bit?
of a particular work. I thought that was really interesting. Partly because this is another one of our questions about the scope of stationers' rights in
Yeah.
the things that they had registered for, right? And we still have this problem in modern copyright, don't we? Like, what constitutes the work, right? What
Right.
is, when we talk about the work, how do we define what that is? So there's some evidence that at least early on, when you registered the work, that really meant that work. And if
Hmm.
there was a translation, that was considered a wholly new work, a
Hmm.
separate work.
Yeah.
And there is this case where Locke is aware that a translation of one of his works has been prepared, and he possibly even gave that translator the manuscript, although I don't think we know that for sure, but we know because of his correspondence, his references to the fact that someone's preparing one, that he was aware of it, but that he didn't attempt to interfere, and that he mentions it in his will. He's taking ownership in the sense of attribution for, he's taking authorship, he's confessing authorship of a lot of works that he never confessed authorship of during his lifetime. And he mentions the fact that there is this translation, and he uses the word privity, but
Hmm.
I had I wasn't privy to it.
Hmm.
And people, well, maybe I'll actually look at exactly what he says. But there had been one of his biographers
Yeah.
who thought that that was a bit cagey, right? So, well, that's not true, right? That's not true. We know that he knew about it.
Hmm.
But I think there's a good possibility that what the word he's using there is privity in the sense of an agreement.
Yeah.
What he means, he's not lying in his will. I don't think there's a great deal of a reason to lie at that point. What I think he's saying is that I didn't have any commercial agreement
Yeah.
with them. That was their own work.
Yeah.
Right.
And he wasn't trying to claim any entitlement to that.
Right,
So
exactly. As opposed to this this moment of claiming authority in the other works that he had never claimed before.
yeah, interesting, interesting. Well, I think I really enjoyed reading this when it first, when he first submitted it, whenever we started getting solicitations for and then rereading it. So I think this is a really great contribution, and builds on the writing, and I hope you continue too on this, because it's really fascinating, just from a theoretical standpoint, what exactly are the source of these rights and the commercial aspect of this. I don't think Locke had an agent, right? There wasn't really a
No.
system of literary agents at that point. I don't think.
No,
Yeah.
not
So
professional ones.
yeah,
Although you got to wonder
you
with
had
arbitration
yeah,
clauses and
yeah. You mentioned
witnesses
arbitration.
being done. I wonder
Yeah,
the role that that lawyer in particular was playing
and
in the
this. Yeah,
creation of
yeah,
these agreements. That
yeah.
at least he had powerful friends who knew the business well,
Right, right.
and I think that still benefits authors today.
Yeah, interesting. And I assume, what did the stationers company have lawyers, or did they have any, represent,
Yeah,
whatever was going on that
yeah.
side, or they just sort of had business people who,
Yeah,
yeah,
I don't know.
yeah,
Although that's an interesting question.
yeah,
These contracts all have, well, not all of them. Many of them have witnesses, right?
yeah,
They're witnessed by particular people,
hmm,
and I do think it would be interesting to track those witnesses down and look at how the social networks
yeah,
are
yeah,
working. Um, because we understand that even today, like innovations in the way that deals are constructed travel, right? That we get
right,
these
right, right,
idea provisions like
yeah,
transactional lawyers learn tools that
right,
they can
right,
use. And I
yeah,
do think there was something exciting and innovative going on in
yeah,
this period
right,
amongst these particular authors who think to ask for more. And you
yeah,
wonder how is that happening? Where is it coming from?
Right,
And
right,
how are the other parties on the other side able to process it and understand how it's going
right.
to work?
Yeah, I'm fast forwarding in my head 200 years and then another 100 years or so, first to Louisa May Alcott and then to the, I don't know if you saw the recent
No,
version,
I haven't seen
Predatory.
it yet.
Oh, because I won't give any spoilers out.
Okay.
Uh, it
I've
does
heard that
end,
there are some copyright
yeah,
issues.
sorry about, it ends on a
Yeah.
copyright issue. It's really pretty interesting and
All
it
right.
does relate to this question of negotiation for,
Yeah.
what was a copyright at that point. So
Yeah.
I
Yeah.
recommend it. You can, it's worth seeing the whole movie, but you can wait for it to come out on, video or paper
Yeah.
or
I
whatever it
usually
is,
do.
and fast forward to the end. But because it is a copyright negotiation, it's pretty interesting, and I think it's based on fact. I haven't had a chance to research it or see if anybody's written about how Louisa May Alcott handled the copyright in Little Women, but
Yeah.
it's pretty interesting. So it was all
Yeah.
done without lawyers too, at least the movie version. So
Wow.
so
Yeah.
about that.
Yeah. I think it has part of the reason why I'm so interested in this work historically is the kinship that it has with the wonderful work that's being done by people like Jessica Silby
Hmm.
in understanding how people on the ground, creators, designers, authors, how they understand their needs, and to the extent that we have a IP misfit or a gap, right? I think the same issue exists historically, and looking to see how they attempted to solve those problems with private ordering, I think is a really fascinating,
Hmm. Hmm.
interesting question.
Yeah, and would that be, I mean, just to go back full circle, since you're nearing the end of our time, we have another 5 minutes or so. So how does that relate then to Locke's notion of literary property? I mean, is it really property at that point, or is it just a nice metaphor, or is it literary property in it's in a fictional sense of, we think about that term. So how would you
Yeah.
think about those
Well,
implications?
think of it this way, right? So there were, I think, um, there have been four concepts, I think, that if you were going to boil it down, four concepts in Locke's philosophy that scholars like Wendy Gordon, Justin Hughes, Leora Seymour, Alfred Yen have looked at in understanding how we would apply his philosophy of property to intellectual property today. The labor desert theory, the no spoliation proviso, the enough as good proviso, and then the idea that commerce is important to our ability to get value out of our labor and therefore our property, right? So in those four concepts, I think we see things like, or we have seen scholars see things like the need for a limit on duration, right, for the spoliation proviso. Wendy Gordon in particular takes a look at the enough as good proviso and talks about the need to limit scope of copyright such that others have the ability to draw on the pre-existing cultural matrix is how she phrases that idea, right? So all of that, I think, given those concepts, we would expect to see as part of his concept of literary property, things like a link between compensation and labor.
Hmm.
We'd also expect him to balance the needs of an author in order for personal control of the manuscript with the public benefit and the public good. And we get
Hmm.
a lot of that also in his theoretical dealings with the political situation of his time, right? So then do we also see those things in his contracts? I would argue yes, right? We do see compensation linked to labor. We do see him limit the claims of his estate in a set of these agreements as well, such that he is entitled to be paid only for impressions that are made during his life. And then in his will, we see him gathering up his works and donating physical copies to a public library,
Hmm.
right? So I think, I know you're asking me more about the the concept of property as a concept, but I resist answering it in quite that way
Right, right.
because of where I began by saying that I don't think the word gives us the dimensions of that
Yeah,
box,
yeah,
right? We should get the dimensions of that box from these other things
yeah, yeah.
that we can draw out of both his philosophy and theoretical writings and his actual commercial practice. And that has really been my project with the chapter.
Yeah, it's a really well executed chapter, and so thank you for contributing it, and thank you for talking about it, spending time the last hour discussing it. I really hope you enjoyed it as well. I
Oh,
got
it was such a pleasure.
yeah. So thank you again, Rebecca.
Thanks so much. See you
Bye.
later.
Bye.